morning. Thank you very much for choosing KTN. Good morning if you're just joining us. We are at the heart of it, discussing the happenings in the country, the status quo, if you like, and national issues. Right at the heart of it is the impeachment of the deputy president, the second in command. On the ground, you say number 2. And I'm here with a very brilliant, one of the most brilliant legal minds in the country. He is the former LSK president and also an advocate of the High Court, Eric Theory. Thank you once again for creating time to be here and staying with us. Before we took a short breather, you walked us through a number of things. What is probably expected, but I want us to also look at what you mentioned earlier on, and a number of legal voices have mentioned as well, that we don't have legislation around the impeachment of a deputy president. You see, it sounds like a statement, but I think it's very weighty in my, understanding. Because fine, we have a constitution, they say one of the most brilliant ones. But when it's around the legislation of the deputy president, of course it says this is when you're impeached, you can be removed from office on these particular grounds, gross misconduct, among other things, abuse of office, fine, that's clear. But when you say we lack the legislation, why don't we have it in the first place? All right? Who ought to bring it? Because it's putting us in some very dire or confusing, situation. And what does this then mean to the case right now in the corridors of justice? Eric?
There was an attempt to enact an act to guide impeachment. And I think that bill is somewhere in Parliament, probably Parliament in their wisdom, or maybe some would say lack of it, decided that that piece of legislation is not an important piece of legislation. But
I'm sorry, there was an attempt. So we've had 13 sitting parliaments, right? This is our 13th parliament.
Yes,
so
but of course, we look at from the Constitution 2010. So this is probably our third parliament.
All right.
From the Constitution. So I know that there was an impeachment bill which has not seen the light of day. The idea behind it was to just provide a procedure for impeachment of the president or the deputy president. It's not specifically for the deputy president because the provisions in the Constitution on impeachment apply to both the president and the deputy president. And for the deputy president, you borrow the procedure for impeachment of the president. So that's a factual position. We had this almost a similar problem when it came to the impeachment of governors and what would happen if a governor is impeached, and the question of also the impeachment of deputy governors and how to fill the vacancy. For the Constitution, for the president and deputy president, the Constitution is very clear. And that's why Parliament had to enact a legislation. But you have to remember that the impeachment of Wambora, the impeachment of Sonko, brought about certain issues. For example, the question of public participation. How do you conduct it? How is it supposed to be done? And you saw that in the DP's case, the court in Kirinyaga had to give us an interim declaration requiring that the public participation be conducted much more widely than had initially been anticipated. And what we expect ultimately is that this case then will be looking at the processes, the procedure, what was done, what was not done. And if we had a framework, a legal framework that then says, once this notice is received, this is what you do, this is what you do, this is what you do, it would have made easier some of these things, because there was an element of innovation, an element of relying on the standing orders. But in terms of hierarchy of laws, the standing orders fall way below an act of parliament and subsidiary legislation. So that was the reason why it would have been necessary perhaps to just have a law that provides for what needs to be done and how it should be done, to just add more flesh to what is contained in the Constitution. Because as it is right now, there'll be a lot of questions around that process and what was done and what was not done and all those things. And then the court may give clarity, and hopefully into the future we can be able to see maybe a legislation, if the courts agree that there are certain areas that in terms of procedure that may require to be supported by a legislation.
And when you say if the courts agree, I just want to walk this journey with the viewer. If we look back at how the legal team representing Gachagua has been moving, they have anticipated quite a number of things before they went to, the courts to stop the motion from being presented to Parliament from the stage one. Then they, made some attempt to have the court's intervention at the Senate level, right at the beginning, the public participation as well, and then the biasness of the three-judge bench. But we have different levels of the courts that might still be, if I would use the word, exploited by the legal team. We have the High Courts, we have the Apex Court. It does not end at this level, does it? This case that is facing the Deputy President, Rigathi Gachagua.
Well, it's unlikely to end at the High Court. It's likely to find its way all the way up to the Supreme Court.
All right.
So that's a possibility. But as I was saying, you see, the Deputy President has attempted to intervene in this process at Parliament and at Senate, and now after Senate has made the decision. So what is in play in court are all those cases and all those issues that he had highlighted. For example, one of the issues he had picked at the National Assembly was whether public participation can be done before he has given his response, because people need to see the accusation and to see the response, and then to respond to it in a manner that is informed, well informed, knowing, having had an opportunity to look at the accusation and the response. That is one of the things that he has raised. The court may actually look at it and say, yeah, wait a minute, he raises a valid point.
All right.
Or the court may say, okay, but looking at the time, maybe it would not have been possible to be able to do this, and so Parliament was right. I suspect he may also question the order in which the proceedings in Parliament were conducted. Because you remember, Parliament moved the motion, it was whatever, then members contributed to that motion, and at the end of their contribution, the DP was given an opportunity to make his response.
For about 2 hours.
For about 2 hours.
Yes.
So at the time he was making a response, the members of Parliament had already discussed the motion. So should they have first listened to his response so that they respond and debate, having had an opportunity to listen to his response?
Allow me to interject. Now, this also came and played out in Parliament. That same time, and I remember it's Mwingi Mutuse, member of Parliament, Kibwezi West, that was moving this and sponsored this particular motion. And he argued, because prior to that, response in Parliament, the Deputy President, or impeached Deputy President Rigathi Gachagua, held a presser with the media stations, and he gave that whole response to the public, all right? And it came out, and Mutuse said he actually went out there and gave his response and explained himself to the public. Does it then count that he spoke to both the Parliament and the public at that point? Because as you bring it in, you're saying if they had done it differently, perhaps we'd start by sharing his response first. But he did publicly the previous evening before appearing before the National Assembly the next day. Does it count?
Well, I don't know whether that will be the response that the National Assembly will put. I'm just saying that
I'm not an advocate.
I'm foreseeing those kind of arguments playing out before the court. And so the court will be placed in that position where it has to make a determination on those questions one way or the other. And perhaps one of the things that the court may say is that if we had a framework if we had a legislation that was guiding this process, maybe some of these questions would have been answered before we got to this position. I'm not saying that they are valid. That is what the court will decide. I'm just basically saying that those are questions that are likely to be posed in terms of process and procedure. And of course, there is nowhere where you have this process and a procedure. And so someone may want to look at it and say, should we have a law or not? Because that is what courts are supposed to do, to look at the question that is before them and to make a determination and to guide the country moving forward. Essentially,
you're saying this historic, case or moment for the country could also be a lesson for us. Do you think the courts and the parliament, if I say, would take advantage of this, depending on which direction it goes, and maybe this would be the foundation on which we will then see the importance and maybe work around a proper legislation and framework around impeachment of either president and deputy president? Do you think it would set a good, foundation for that to actually now be implemented in practical?
Yes, definitely.
Yes.
Doris, let me tell you this. In the world, we've not had, across the world, I think we've had about 10 impeachments of presidents. That have gone and have been successful. But there have been probably more attempts at impeachment of a president. And I use this to touch on both president and deputy president. But what does that tell you? That there is very little convergence in terms of jurisprudence on how to deal with the question of impeachment. But let me just illustrate to you what I mean by that, because this is historical.
Yes.
We have majorly two systems of government, a parliamentary system and a presidential system. The concept of impeachment first arose in parliamentary system, where easily people will say we have no confidence in you and release you. And in the past, before we moved to a pure presidential system, a motion of no confidence could be moved on an MP, on a cabinet secretary, and if it passes in parliament, then that person is removed. So that is an impeachment. So in essence, the purpose of impeachment has been sometimes to remove a person who is unpopular as a political leader.
All right.
That has happened in Brazil, that has happened in South Korea, I think, where the president, because of initiating or taking certain actions that make them extremely unpopular, then they are impeached by parliament so that the political unit can continue in office. And so that is the first one. And then the other angle in a presidential system is to deal with a bad, what you call in law, a bad actor, a criminal, or someone who is using the office to shield people who have committed crimes for the benefit of the president, or a president who has committed crimes and is using his office to prevent action being taken. This has happened in the US in the case of Bill Clinton, in the case of Donald Trump. It has happened in South Africa in the case of Jacob Zuma. So that it was a criminal investigation that then triggered the removal of Jacob Zuma. But Jacob Zuma, it is not a the impeachment process is not like in a pure presidential system, because the president is appointed by parliament. So what they did is that they then sort of passed a motion of no confidence in him, and he had to be removed, and the party appointed a new person. So you see that historically, impeachments serve two purposes. To either remove a leader who is engaged in criminal activity, And you can see in one of the things, one of the grounds that had been moved against Gachagua was there grounds to believe that he had committed crimes under. So that is a criminal or a bad actor. The second one is now, in our case, a question of politics and ethics and governance. And so Gachagua was removed on politics and ethics and governance. So what is the threshold that is given? The threshold that is given is that Parliament will impeach you with a 2/3 majority, and Senate will impeach you with a 2/3 majority. So for any person not to be impeached, they must ensure that they have support of the House that is at least 1/3.
Right. So
when you are removed as a deputy president because you cannot be able to garner support in the House of 1/3, the question then becomes, should the court intervene and return you when clearly on the aspect of the impeachment process that is intended to deal with lack of political support or political bad behavior that makes you lose political support? Remember, there is a system, there are parties.
Yes.
There is a minority and the majority.
That's right.
If all of them can come together, irrespective of the motivation of them coming together, but if all of them can come together and you cannot get at least 1/3 of that support, should the court then reinstate you to an office that is largely political and in a process that historically is intended to deal with politics when a leader loses the support of his political parties?
Very, very pertinent, questions you're raising. And Wakili, if that is then one of the ways to look at it, someone would argue then that, Gachagua's team, representing him, have brought in some two major issues, among others. The role of the IEBC. If you look at what's up, because I know the common Mananchi is watching, there is openly so much information flying around, some misinformation, some just created then to just create some sort of tension, what we will refrain from. Is there's a way then a deputy president is appointed in a general election, all right?
Yes.
All the way from the nominees, checked, approved, IBC, is it the chair or the commissioners? All that is now out here in the conversation. So what is the role of the IEBC? Because they're saying, if the IEBC is not properly constituted, who has cleared the deputy president designate at this point in time? And I mean, why is there a concern or contention around the role of IEBC within the courts right now? Would it make any difference for Deputy President Gachagua?
I think it would make a lot of difference for him. And if I were him, I would hang on to that argument. And this is why I was basically saying that we are operating in an area, a gray area. Why? Because when it comes to, for example, when the Supreme Court gave certain directions in terms of how we should fill in a deputy governor when he is removed because there was no provision as of that, it said that the IEBC had no role in that process. Now, if you read the Constitution, what it provides for in terms of the replacement is that the president has 14 days to submit a name to Parliament.
Right.
Immediately after the resolution, but he receives the resolution of Senate of a removal, 14 days. Now, within 60 days, Parliament is intended to debate and vote. That is what the black letter of the Constitution says. So then the questions that are then going to be before court was this requirement met? Then the other questions then will come in probably. Was there supposed to have been a process of public participation? So that then you can look at all those things. There was, of course, a clearance that came from IEBC. Was that a proper clearance? Because one, the courts have already interpreted the Constitution in terms of what constitutes IEBC.
All right.
Is this a case where the Secretariat can handle because it is largely administrative, or is it a situation that requires the existence of commissioners? So those are questions that are going to be live in these proceedings. But for me, I think the most significant question would be the question of being able to have a clear way forward in terms of the position of the deputy president. That, in the interim, I think is what the court is going to focus on, because my suspicion is that the court cannot be able, in view of the many cases that are there and the many parties that are there, cannot be able to hear and determine those petitions within the shortest time possible, to be able to allow every party an opportunity to argue its case, and then for the court to make a final determination as to whether the process was constitutional or not, whether the deputy designate President Kindiki was appointed, Professor Kindiki was appointed properly. So the court will find itself in a very difficult position, balancing all this. And remember, there is one thing.
Yes.
That courts have always said that the process matters. If the process is not good, the end product cannot sustain. That is what the courts have always said. So they will want to look at the process. That is obvious. The other one is that courts have also said that when it comes to public office, there is no right in the nature of a proprietary right. And so that an argument that you are likely to suffer damages as a result of your removal from public office is one that the courts have always disagreed with. The courts have always been of the view that they can hear the case, make determinations, and if arising from those determinations, then you can be able to find one way or the other out of it. So to be quite honest, I don't envy the position that the court will find itself in, but I hope that in the shortest time possible, the court will be able to give us some sort of certainty and a direction that will enable us to understand as a country where are we going with regards to the office of the president and the deputy president.
And I like that you said that in the long run, the certainty is needed around the office of the deputy president. And the question still remains, I mean, who is the deputy president? Some saying we don't have a sitting deputy president at this point in time, but we want to appreciate Wakili here saying there are certain key orders in court, and these two legal teams are looking at either these orders vacated or upheld, so that then we can see who will this work in favor of. Wakili, talking about the process, denial of fair trial. If there is a conversation, I think if you looked at the public opinion, there was also a lot of mixed reactions around it at the Senate level. It was very, very interesting.
Yes.
When the deputy president, impeached deputy president, allow me to refer to him that way, was fell ill just at the 11th hour, some would say, of his fair hearing. You know, the 5 hours given to him by the Senate, and he failed to appear, and the Senate proceeded. You know, either way. And you have talked about, and I don't know how to put it, the end justifies the means or the means justifies the end. But at this point in time, denial of fair trial, I don't know, what is your, what would be your argument? I know we still have the court handling this matter, so I know you might refrain from other details, but from your own legal lens, do you think this is a ground because we're looking at also another concern of investigating crimes. There are arguments that the Senate ought to have investigated these allegations. We're looking at 11 grounds of impeachment, if you followed closely that particular impeachment motion, that the Senate should have investigated these particular allegations. And number two, they should have then given him a chance to defend himself or present his defense. Now, these two things around how the Senate behaved, because you're saying the courts are very big on the process. Talk about the Senate and how it behaved to that point, the two things that I have mentioned to you.
You know, the Senate found itself in a situation that was not anticipated. I think that the Deputy President was expected to give his testimony and to be cross-examined in the afternoon.
He was a chief witness, I believe.
Yeah, he was the one and only witness, and he has a right to appear and to be to present his evidence and to be cross-examined on his evidence. Unfortunately for him, he was taken ill, and I think what happened is that the Senate then was left with the option of proceeding on the basis of the documentation that had been filed before it. Remember, what the Deputy President was coming to do was not to give any evidence outside what he had already given, because it was a response to those to the submissions. His lawyers had questioned the witnesses for the National Assembly in terms of the allegations they had made. And so it was his turn now to then be questioned on any of the on the responses that he had made, and where Senate felt like they needed clarifications on his response. That was his opportunity. And so
clarifications.
Those clarifications. And so when you look as against the timeline, they probably had very little room to maneuver. The other challenge, of course, and then the court will, of course, also examine all that, because they had up to Saturday, so the court can say, I mean, maybe you should have given it one more day, but then given it one more day, the circumstances then were that the Deputy President had just been taken ill. The priority of the medical team at that particular point was in establishing maybe his condition and trying to deal with his condition at that point. And so they could not even give a prognosis of when they think he might be available. And so that there might be a situation where even if he had been given more time, maybe he would not have appeared. And we understand as lawyers the place of what we call written submissions, or a written response. And even in so many other cases where a party fails to appear in court for good reason, the court can still proceed to determine the case on the basis of what has been written down. Because in most cases, you do a comprehensive response. And what happens is that there are certain things which will just be tested in terms of the veracity of the things that you have said. And so there are certain, you know, the way law operates is that evidence, even when presented, has its own technicalities. And so when you are being cross-examined, it is being tested on those technicalities.
All right.
But the court can still make a decision and arrive at a fair outcome, irrespective of the fact that a party has not come and has not, and the other party has not had the opportunity to test certain things.
Interesting, Wakili. I want to talk about the concerns around the empanelment, because anyway, we're seeing this particular concern now going deeper. It's major, because I think both parties should be confident in the judges that are listening or hearing this particular case. I don't know what your argument would be or your observation at this point in time, because we are looking at these three judges who are still then forming this three-judge bench. The concern about the DCJ, empaneling this particular judges came up yesterday very intensely. Justice Eric Ogola, Justice Anthony Mrima, Justice Freda Mugambi, they were very, very firm in their submissions yesterday, and they actually called out the legal team that felt there would be a bias, and they actually termed this particular attempt as they used some very interesting vocabulary. I'm trying to get that. And they said that the lawyers were casting aspersions about the judges in as far as the impartiality is concerned. They said the functions of the CJ are political, the constitutional, and administrative, and that the DCJ could as well empanel this particular, judges. But I want to hear your thoughts on this, because we are looking at this group, this bench, also then agreeing on the consolidation of the cases. But how did they arrive at the fact that, because the Kenyan is asking, what are these administrative roles, constitutional roles, political roles that the CJ has, and what does then a deputy as CJ get to do? Because the challenge here was that she did not do it as is expected. So maybe the arguments yesterday and how we got to this is where I'm going to. Why is this particular bench still proceeding today? Maybe in a nutshell, a summary of how that played out and why then we shall proceed.
We are yet to see the written decision.
Okay.
From the court, but I want to say that the court proceeded on these two bases. One, that previously there was a case by a gentleman known as Conchela against so many other people, and one of the parties was the Chief Justice. And in that issue, in that case, there was a question as to whether, and it was a 5-bench.
Okay.
There was a question as to whether the DCJ, because the panel then was set up by the DCJ, there was a question as to whether the DCJ can actually set up a panel. And in that case, the court said yes, the DCJ can set up a panel. But in that case, you see, the CJ was a party, and I think in this instance, the parties were trying to distinguish to say that that case, the CJ could not, because he was a party, and it would have been manifestly unjust for him to appoint judges who are going to determine a case where the CJ is a party.
All right.
But I think flowing from the Conchela decision, this 3-bench has also affirmed that whereas the Constitution gives the Chief Justice the prestige of setting up this bench, the question of setting up a bench is largely administrative. Administrative in the sense that the CJ does not do anything more. He just looks at the judges, looks at the workload, consults the principal judge, for example, and tells him, which judge do you think are don't have so much work? There are so many other things that they look at before they decide they'll give these judges.
Okay.
So the CJ then just appoints those judges and says, these are the judges. Then those judges are informed, you've been appointed to this panel. Then they take up the case and they proceed. So on the basis of that determination by Conchela and on this one, I think that the 3-bench is largely correct. Correct in the sense that they have also distinguished. You see, the Chief Justice is the Chief Justice, President of the Supreme Court, and President and Chairman of the Judicial Service Commission.
Chairperson?
Chairperson of the Judicial Service Commission. Of course, the word chairman is still correct. But
is it?
Yes.
Now we have a female Chief Justice.
Even for a female, the term chairman is actually gender sense inclusive. But anyway, that is not the point. But what I'm basically saying is that the office of the Chief Justice has like 3 or 4 different functions that have been put together, and I could see that the bench was highlighting, for example, that whereas the Chief Justice is the head of, is the chairperson of the Judicial Service Commission, it does not follow that the Deputy Chief Justice is the Deputy of the Judicial Service Commission.
Right.
Yeah. So that the Chief Justice, when it comes to the judicial administration, she is the head of judiciary administration. And then the second in command in terms of judiciary administration, and you see administration as small things like even approving maybe leave. This judge wants to travel out of whatever, he is on medical leave, he has, all those administrative things.
All right.
That those functions are now the exclusive reserve of the Chief Justice. In the absence of the Chief Justice, or if the Chief Justice, for good reason, is unable to exercise that function, then the Deputy Chief Justice exercises the function. So I think what the court was saying is that it would be intrusive to go back to the Chief Justice and say, Chief Justice, can you give us a reason why you did not exercise this function? Yet it is very clear that if the Chief Justice, for example, is not there, and there is an officer who requires to go on leave, or there's something that the Chief Justice must sign, he'll just call the Deputy Chief Justice and say, I am out of town, there is something on my desk, please approve for this officer to, travel out of the country, or maybe needs medical treatment and it needs approval of the judiciary, so give that approval. I think that was what the court was trying to say. The question here was not, in my view, so much the fact that the bench was constituted by the Chief Justice.
All right.
It was perhaps a feeling that as a result of the application that had been done by the Attorney General to set aside those orders, there was a fast tracking of the case, and the case being heard on Saturday, which in my view is not something that we have not seen, because there have been situations where the extraordinary nature of the case has required a hearing on a Saturday.
In fact, even as you speak on that aspect of sitting on a Saturday, there was this clarity that in the past, or how you're doing things right now in the corridors of justice, is that you sit, or between 8 to 5 p.m. Is that how the courts operate right now?
Yeah.
And I think one of the justices was, or judges, suggested an amendment to that, and also said then there's need that when a case is filed past 12 p.m., it's just not heard the following day. The same way you went virtually. Do you think these are things that are proper at this point in time? Because they're coming up right now, that why Saturday? Now it looks like it was fast-tracked, but you can see that there is a judge who said the courts can meet at any particular time necessary. Now, the contradiction, Wakili, for people like us who really do not know how courts operate, is huge. Is it the judge that is right? Is he saying what he thinks should be done? Is that how things are done in courts? Because the lawyers and litigators are equally legal minds who are bringing up this issue of sitting on Saturday, looking like you're biased to the executive, and the way things have been done, 8 to 5, and if any application is filed past 12 p.m., it's heard the next day.
I'll tell you this. When I was president of the Law Society, one of the things that we were trying to deal with is just what the judges were talking about, the fact that with the online system, there are certain practices that we used to have that no longer that are inconsistent with the online system. One of them is that thing of saying if you have to be heard on a certificate of urgency, then you must file it before 12. Back then, the requirement to file it before 12 was so that the physical file can be taken to the judge, then he'll have the opportunity to review it and to make up his mind But now there is an online system. You file a case, the case is automatically allocated to theory. So if I am sitting somewhere on my laptop and I'm doing my work, and then I see there is a certificate that has been allocated to me of urgency, I read it, I see it has a lot of urgency and a lot of merit. As a judge, should I say, because it was filed tomorrow, even though I see this thing, it's so urgent, I have to wait until the following day so that I can give my order. Yet I've already read the certificate and I am certain that I'm going to give that order? Shouldn't we do that? So we have seen, and I will say this, we have seen cases of increased efficiency in the judiciary as a result of the online system.
Okay.
You file your case at 8, it is auto-allocated to a judge. The judge is probably not in his chambers. He looks at your certificate, he gives you the orders there, and you get it, and that is a good system. Let me just put this thing into context.
Yes, Wakili.
Any party in court, it doesn't matter even in this case, any party, if today a client of mine maybe wanted to sell a property to recover a debt, and the owner of that property goes to court and gets an order to stop us from selling, I will be filing another certificate before the court trying to set aside his orders because I want to help my client to get to sell the property so that he can recover his debt. So we are on two different platforms.
Okay.
So this person who has filed this application will want it to be heard within the shortest time possible, because the moment he gets the order that the property is not being sold, his anxiety eases. He is comfortable. Now imagine me on the other side. I want to sell this property. We already have a buyer. He has come, and this my client knew that once this is paid,
Yes.
So he has. I have as much urgency to set it aside, and this other person has less inclination for my application to set aside these orders to be heard. And this is what is at play here.
All right.
Yeah, because if the orders are set aside, Kindiki is sworn in, and the deputy president, and that matrix is now resolved. The case will not stop. The case will continue. The case will continue because the swearing in of Kindiki will not stop. If it happens, will not stop the continuation of the case. The case will continue. The argument about whether it will be academic or not may be there, but you see, at the end of the day, some of these matters help the court to refine jurisprudence. It's like the court cases that have gone on elections. They have helped the court to refine so that we now are at this point where we know that the vote at the polling station is final. That arose from a court decision.
Right.
So the process, the court cases will go on. They will define so many things in terms of process, in terms of all those things. But it is against the interest of Rigathi Gachagua for these orders to be vacated. But it is in the absolute interest of the state to ensure that these orders are vacated, because the state would want to know who is the deputy president.
Indeed.
Who are we dealing with as the deputy president? So don't look at it so much in terms of, the issue of how the panel was, whatever. Those are just what we would call, for example, legal gymnastics, or my friend Mudomi Thiankolu calls it legal sophistry.
All right.
Yeah, but at the bottom, the most important thing that is in contest right now is whether these interim orders will continue to operate or not.
Very, very interesting. And if you're still just but joining us, we will continue to follow you and pick you up from where you are. All right, so if you have any questions, we are up and running on social media, even if you're going about your business, because other Kenyans are going about their business, and it's important that you put food on the table. But also, keep your eyes on the national issues. Right now, my team is already on the ground at the Milimani courts. You've been seeing once in a while there. We are giving you the pictures live from the Milimani courts. The number of advocates have arrived, the familiar faces, if you've been following this representation and the battle of legal minds in as far as the Deputy President impeachment trial is concerned. Judges have so far dismissed the concerns over empanelment. We're looking at consolidation, rather, of these cases being looked at today as well. The mood looks pretty much calm. as should be in this arm of government, but we will cross over once the hearing begins. But essentially, that's what the big business of the day is. I'm here with the former LSK president, Eric Theory, who will continue to analyze, what's happening legally and what is probably expected. Remember, matters of the court are not really to be played around with, but it is our duty then to make sure that you are not left behind, as this is very key position of a deputy president, second in command. We take a short breather. We'll be right back with more. Don't go too far away.